Names of those two, one young girl and young boy, argued that matter. Their names we need.
Or intervener, one of the intervener and
both are interveners. Both are interveners. That those names I have left blank. Those names we will add. Consider their this will also dismissed. Not interfere. Mr. Sahu appeared only for the respondents.
yes.
He has not filed any appeal.
No. Only for the
They
rest.
have proceeded that way.
That is in sub-item.
Item number 2, Writ Appeal
We have
197.
given 3 months for implementation of the order.
Well,
Yeah.
Item number 2, Writ Appeal 1978 of 2024.
there is a delay of 583 days,
Yeah. But
But
the
all-
matter on merit.
But all the way, this is covered by your Lordship's judgment. That is Krishna Chandra Malik, that 18.3 and 18.6 of the job contract employee under the pension rules and the
That what we have said in it.
that is
We have made
in,
against you.
that I can supply it also. The 3 matters are there, even though there is a delay.
Right.
That was in 2, 3, 4.
2, 3, 4, all are the similar type matters.
Give that.
I'll give the reference.
Ah, this appeal, this Silver Court appeal seeks to lay a challenge to a learned single judge's order dated
11/11.
11/11,
2022.
2022, whereby respondent employees WP number 38088 of 2021 having been favored, the following relief has been accorded. There are 6. Next paragraph. Having heard learned counsel for the learned AGA appearing for the appellant and having perused the appeal papers, we are convinced that the subject matter of this appeal is substantially similar to the one in writ appeal number.
I'm giving.
Yes.
His name is Krishna Chandra Malik.
Between Krishna Chandra Malik.
State
That's state versus Krishna Chandra Malik.
Sudhanshu Jena case, which has been remanded back on the ground of limitation one.
Yes,
I'm just 10 minutes.
Disposed of by us wide order dated so and so. And therefore, this appeal too has to meet the same fate of dismissal. First, ordered accordingly, and writ appeal is rejected in limine. First, registry to send a copy of this order to the respondent employee immediately by speed post. First, before that, order of the learned single judge to be implemented within a period of 3 months.
I'll supply the copy.
I'll give that, sir. Next 2 matters are also.
While at that delay part, that
one aspect of in all the 3 years. Even otherwise, next paragraph. Even otherwise, we do not undertake deeper examination of the matter in as much as appeal has been filed after brooking a long delay of 583 days. Okay. And the explanation offered for the same in terms of application in IA number 5199 of 2024 supported by the affidavit does not constitute a plausible explanation, delay being too long. First off, the sages of law have always said that a litigant who sleeps over his rights cannot one fine day, get up from the deep slumber to knock at the doors of God successfully. First one. Next. Yeah.
Item 5,
No, 3, 4, 5 is the
Same.
2, 3, 4. 2, 3, 4.
3, 4.
2, 3 and
3, 4.
We'll go to
Delay. See, in delay.
everywhere there is a
849.
delay may not.
Another is 698.
to 5.
item 5, rate appeal 2012 of 2024.
Separate order.
I am supplying the copy.
Ah.
Item 5,
Fairmont.
Ah.
It is also same. The same one.
Yes,
Just
it
it
is.
is 7. And
Normally the state appeal, of course, it has been allotted to.
No, same order.
My lords,
Covered by judgment.
my lords judge.
Correct. You that.
Exactly that customary.
again, Kutum.
Identical order.
Delay
698.
Delay is there.
Delay we have. We have now rejected your delay application. See this. Yes.
item 6, rate appeal 2033 of
That copy has been given.
Yeah. copy has been. Thank you.
They are also the same.
It's also same.
Same.
Is also same.
Yes.
Item 7, rate appeal 2314 of 2024.
Yes.
Yeah. Yeah.
Same.
Same.
Yes.
Item 8, rate appeal 2773 of 2024.
This is Sarat Chandra Paradakis, probably we have.
That is pending, my lord.
No,
It is
yes,
in the
but
month
We have
of
issued
April.
notice and posted it to
April. my lord.
issue emergent notice.
That is 197 of 2024.
Up to service of notice. Post this matter along with writ appeal number 197 of 2024. Okay.
Item 9, rate appeal 2805 of 2024.
Same, Sarat Chandra.
Yes.
Item 10, rate appeal 2806 of 2024.
Brother, one thing, see, 650 days, odd days,
670.
that we have made that you have to deposit that money in the registry at the rate of 20 rupees per day. If you do that, then we will issue the notices in other
My
ways.
lord.
Item 8. Sentence. There is a the appeal has been filed up looking the long delay of so many days, and an application has been filed supported by affidavit seeking its condemnation. First off, since delay is long, we are putting the appellant to the term that he should deposit, they should collectively deposit the amount at the rate of ₹20 per day of delay in the registry as a precondition for consideration of the said request for condonation of delay within 3 weeks. Writ appeal, the application stands rejected, and as a consequence, appeal as well.
This is item number 9, 10, 11, 12.
9, 10, 11, 12. Days also, days will, number of days will undergo change.
According to the amount.
8 also. That's
8. Not 8, 9. 9 onwards. 8 is
No, notices. It is the selection for you. See, same.
Millard, in that particular judgment, my lord says category stated in 5.8 So for that period and each case is to be considered, my lord. That has been taken care of by my lords.
Correct.
That will be taken care of, 5.8, my lord.
5.8.
Of the judgment, my lord. That judgment is,
We
Oh,
have
you have given that.
that you need that paragraph to be reproduced.
My lord. My lords, may simply say covered by this judgment. Question.
Yeah, we have said that way.
Your lordship.
my lord says dictated in item 2, my lord.
Item two.
But 5.8 clarifies my lord's views in the judgment itself, my lord.
5.8.
Yes, ma'am.
Dismiss confirmation. Covered by this, yes.
No, we will not observe that. No, we will not observe that. We will not.
The statement similar, my
Let
lord.
us see. We will not. Yeah.
Notification.
Item 13. Date appeal 357 of 2024.
My lord, on behalf of appellant, due to illness, the matter may be
Not well.
adjourned.
You are for the appellant.
My lord.
Just turn the pages. We will not dismiss. Turn the pages. We may admit also. You don't have file.
On behalf of
You are a proxy.
on behalf of
You are a proxy counsel.
my lord.
2 weeks.
This court, judgment for 2 weeks.
The appellant of the ground of health, on health ground of arguing purpose. Yeah.
Item 14. Date appeal 625 of 2025.
19 days. Limitation.
Item
1019 days.
Say 1019.
Huh? No, what is the matter on merits? Let us see. If there is something on merits, that we will consider. Kindly come to para 7. You have admitted the legal position before the tribunal. In OA number 98 of 2017, a particular relief is granted to an employee.
My lord.
And the legal position on which that relief is accorded, you have admitted. Therefore, another single judge has said that way. Okay, you cannot go on changing. Government is not a chameleon. It cannot go on changing the colors. And that apart, see that Sanjulata Sethi matter has been affirmed by the apex court.
Dismissed on the ground of limitation.
Limitation also. But anyway, the other aspect, the reasoning which the tribunal accorded in another matter,
Yes.
that legal position you have admitted before the learned single judge. Is it your case in the writ appeal that you did not admit? If you have taken up that ground, we will issue notice.
Can you pass on one?
All right, pass over.
Item 15.
We have already decided similar matters. Myself and Sahu Sawa, we decided similar matters against the state, I remember. Yeah. Yes, next.
Item 15. DWPC 2051 2026.
Wait. Of Baroda. Pass over, let us see.
Item 16. WPC 5003 of 2025.
It will be okay. I need some more time to have some instruction as well as previous.
Can we give time? Short argument. Or 2 weeks at the request of. Finally.
Any date will commencing 30th.
No, immediately after 2 weeks it will come. Within 1 or 2 days it comes because depending upon load on the calendar. Yes. Next.
Passover, I think 14.
My lord, item 14.
14.
Here, the appointment was made in the year 1996 on a contractual basis.
1996. As
On contractual basis, appointed as pharmacist, MHU, contractual basis on 29/2/1996. His services were regularized on 30/10/2008.
Ah.
I do not know whether 1/1/2005 that amendment rules. My lord, it speaks, my lord, the persons who were appointed on that, after 1/1/2005 will be guided by the NPS. And those who were appointed prior.
No, but that date is extended to 1/9
1/9 only.
in another judgment.
Yes.
Ah.
But here, the appointment was 1/9 to 2005. But here he was regularized on 9/30/10/2008.
Ah.
It is much after thereafter.
What is the explanation for the long delay?
Delay,
But that's all right. But did you take up, see, in that OA 98 of 2015,
my lord.
you have admitted the legal position. You cannot have double standards. Have you taken up the contention that we never admitted before the learned single judge, however, learned single judge of just this way, casually?
No, it is not there. Rather, it is stated therein in paragraph 7 that since the claim made here based on settled position of law, without entering into the factual aspect, this court strictly observed that the finance department orders herein also impugned the original application number 98 of 2015. The tribunal, after taking all factual aspects involved therein and further taking into the developments through SLP, my lord, and the review settling the position in disposal of the original application of 98 of 2015, has come to hold that the orders that Annexure 8 also being impugned herein were set aside for there no dispute regarding the position to the law in this respect, as has already been settled
Yes.
through the judgment.
No, admitted the settled position of law.
That is what it is settled there.
Correct. But unless you have taken up in the contention in the appeal memo, no, we have never admitted, or what has been admitted is wrong. At least that also you have not taken. Two options are available because of apex court decision.
My lord.
One, you should say we never admitted the legal position. Number two, even if we admitted, that is not the correct legal position. For when there is admission at the bar, the judges decide on the basis of admission.
Admissions.
It's called concession, legal concession.
Legal concession, my lord. Lordship.
That legal concession is a wrong legal concession, is not your ground.
It is not a ground there.
Not a ground.
Honorable court while disposing of the,
They have followed another judgment.
yes.
Otherwise, what happens is, one employee will get the relief, other employees will not get the relief. That creates heartburn. That will cast some doubt on the judges.
My lord, here, this is the position, my lord, I am submitting, that he was regularized in the year 2008.
No,
So,
no, but you have already taken him to the regular establishment on 24th of January 2005. See your letter, Annexure 2.
Therefore,
You have already taken him, though contractual, but under regular establishment, and posted to the station noted against each. That was on 24th of January 2005. So once the employee is taken
regular department.
to the establishment, pensionable establishment on regular cadre, may be contractual you are giving, but against you say under regular establishment.
my lord,
Now you cannot say. So he is already there in the establishment, pensionable establishment before the notification. 1/9/2005.
1/9/2005.
1/9/2000.
This is 1/1.
Okay, much before.
No, that will be
1/1, but it is effective on 1.
On that date, the notification was made with
But it
effect
was
from
1/1/2000.
That is retrospective, but according to the judgments, we have taken it
The Lordship
To
said that
19/2005.
2005.
So it is on to 24/1.
This is much before 20, that is 24/1/2005.
Commenced. That might be process as
my lord, that's
Good. Dismissed. What on the exam then? Delay.
Delay is one.
My lord, mercifully dictate the order.
No,
My lord, pardon to mention, my lord, item 9 to
1 second, 1 second.
9 to 30.
12. All are identical matters. And the lead matter is WA number 197.
Yes, we have mentioned it.
My lord.
Yes,
that-
but delay,
Delay-
you have said you have to make payment in the registry,
Right.
then we will issue notice, not otherwise.
If we make the payment, my lord, then
Yes,
it will
notice
come
will
along
come.
with that W.
Along with that.
Yes.
Yes,
That.
money is important.
Yes, the delay is 600 above days. More than 600.
The order to be implemented within 3 months.
This one.
Then, that's fine.
Item 15, Kasura item 15, DWPC 2051-2026.
It took time.
No, the bank has gone.
It took time, no possible.
Item 191.
191.
The state appeal
Ah.
file on the which was delayed. Till yet no delay has not been condoned, nor yet admission. But the matter led to pension and the petitioner, the respondent, who is the succeeded with a single judge, now is bringing the cancer and treatment, order on treatment. One night.
My lord,
I only pray. Monday in the first list. Monday in the first list.
One day we have difficulty.
Tuesday.
Many matters are.
Tuesday.
Which day? Suppose Tuesday we have more matters than on Monday.
A supplementary list it will be required.
No, we'll see.
So that is, we'll take it for 23. On 23.
my lord,
My obligation. In the supplementary. My 191.
my lordship, one surfacing matter, petitioner's house going to be auction on Monday. WBC number 7998 of 2026. Amresh Mia versus LIC HFL Finance. Kindly take up to today or Monday, my lord.
Monday. All right, good. On Monday. Monday morning you mention it.
My lord.
Auction is on Monday.
My lord.
What time?
11 a.m.
11 a.m.
My lord.
Call that. Fine. Do that. Now only call. Where is that file number? What is that number?
7998 of 2026.
Finished. So suppose if Monday property is sold before we take up, again many problems will arise. What is the amount involved?
63 lakh 76,000 and the outstanding of the 6 lakh 35,000 to 203. Outstanding the
Only 6 lakh?
pending EMIs, 9 EMIs and other interest.
You pay 7.5 lakh.
Yes, that pending
Today.
EMIs.
Huh.
Yes, my lord.
Okay.
My lord.
Good. Challenge is to the, what is it? What is that number? Take that number.
That file is not in.
No, all right, but what is that number?
The WPC 7998-2026.
It not yet loaded to the.
No.
Action of recovery constituted under the Surface Act
My lord.
2002. First of learned counsel for the petitioner, borrower or a surety?
Baror.
Borrower submits that since installments quantified at about 6.5 lakh have not been cleared, entire loan is recalled, and that the property is now put to auction. I think for under section 13(4) of 2002 Act. And therefore, the same be interdicted. What you said? No, before that, 13(4) of the Act on imminent Monday, that is Monday will be 16/3/2020. It tells that if client is ready and willing to clear all the installment and
9 EMIs are left.
9 EMIs.
9 EMIs.
He submits that. He submits that as many as 9 EMIs that have fallen due to be cleared by the client on or before client before sunset of tomorrow. All right. Sunset of tomorrow. Next person in the above circumstances. Well, let's come now. The auction scheduled to be held on Monday shall go on, but as scheduled. But it shall not be confirmed. Call this matter on Tuesday. On Tuesday, if you do not comply, then it will go, matter will go. Tuesday. All right. In the daily list, supplementary list. In the supplementary list. First, petitioner is put to warning that in the event 6.5 lakh you have written, right? That 6,65,203. Petitioner is put to warning that in the event it does not remit the amount undertaken before us, the petition runs the risk of dismissal on that ground itself. And cost also will be imposed. Yes.
You will get the order today, deposit it.
You have to deposit it today or tomorrow.
Tomorrow, my lord's holiday. It
What
is
holiday?
second Saturday.
So make it today only.
Today, yes.
Today you have to deposit that money. Take this order and ask your client to deposit. Okay. Deposit that money to the loan account. To the loan account. Okay. Get that order. To 24 things. And even that particular warning flag. Okay. Want to cookies also there? Yes, sir. It remember? Tell them to receive. Tell that please. Why so many? 20? So when you put it on 20th. Within that they have to come. 2 weeks under your rules. 20th.
20. Item
20th of April.
20th of April.
Because this 10%. 27 is holiday. 20th will be too early. So you will take it on which day?
10th April.
10th April.
Just Friday.
10th April.
Pardon me, Lord. Item 4, the petitioner is a open heart surgery patient, and he has a vouching 1,68,000 rupees RSCP and grade pay of 4,200.
We have issued notice now.
Yes, but your lordship directed within 2 months it should be complied.
Correct. Therefore, we are issuing notice now. Let it go.
In this, yes, a short date.
Not a short date. It's a normative way. You will get that. Wait. Yeah, because that.
Item 28, WBC 333.
I have put a question on my lord. I am highly a modification application. Because in paragraph number 1 of the order,
What is to be modified?
paragraph number 1 you mentioned that on top of
Make use of mic.
this is a similar situated case.
We have rectified that. Application is fine. Seeking rectification. It is supported by review. In view of that, rectification is ordered according to registry to furnish rectified copy free of cost if applied.
Item 29, review petition 233 of 2025.
None of these call up to 2 weeks.
Item 30, review petition 234 of 2025. Item 31, WBC 11481 of 2025.
Item 31 minutes. Just now I received the objection filed by the opposite party. I'll just go through it. I'll make my submission on the next date. Kindly lordship may kindly call the matter next week, lordship.
All right.
Like, it's already covered by your lordship's order. Regulation matter.
20th.
Regulation matter already covered by your lordship's order. 30 years of service. Anything?
20th.
20th. Grateful. Lordship, I am applying for opposite party.
Okay.
Grateful.
Your name appears in the recordation.
Senior name. Senior name appears. He said.
Your senior's name appears. Yes.
Item 32, WBC 22592 of 2025.
Passover.
Passover.
Passover. Passover.
So I am the IA petitioner here.
He wants a Passover.
Let it come next week.
Next week. That's the request.
23.
Yes.
Item 33, WBC 2567888 of 2025.
Lordship, kindly see the order dated 30th January, my lord, 26. Lordship directed to state to comply the order, failing which, my lord, the severe contempt action will be taken up. And thereafter, also, again, it was adjourned at the instant of the state, my lord, on 13/2. Till late, my lord.
Yes, Mr. G.
My lord.
Your officer does not want to cover order.
Also indicate that includes imprisonment in the order dated 30th of January.
Execution proceedings they are.
Yes.
Why that they have not been implemented?
An order of 2023, my lord.
2023.
My lord, judgment of the tribunal is 2023.
This court-wide order dated 30 January 2026 had said as that. First one. Despite threat of contempt action, the OPs are not offering any explanation.
My lord, one explanation is, I do not know whether it is.
And thereafter, it was again adjourned on 13/2 at your instance.
It was the
Last chance was granted.
one affidavit was filed.
Next sentence. Then 30 to 2026, Learned AGA, Mr. Mohanty had sought, learned AGA had taken time to confer with his client, official clients and come back. First time. Today matter is posted and not even a leaf is turned by the officials. First time. This is a fit case for arrest and detention of who is the person?
Secretary of the department. OP number 1, the secretary, the school and master's department.
Fit case of
Lordship,
for
Lordship, give me call this matter on next week, my lord.
nothing
Next-
will happen.
Next Friday, Lordship. I call.
Who is this secretary? Why he is so adamant?
No, this must not have been brought to his notice.
Yes, Lord.
I'll bring it to his notice. Lordship, I call this 20th.
This
Lordship,
is a
I
fit
call
case for arrest and detention of the violators of the order. First off. However, at the request of learned G, that coercive action is not taken at this stage. First off, it may be taken on the next date if compliance is not reported. First off, matter reluctantly adjourned to 20th.
my lord.
First off, a copy of this order be supplied to, a carbon copy of this order be supplied to the learned AGA.
My lord.
Yes.
Item 34, WBC 28990 of 2025.
Modification, correction of case number.
Yeah.
Correction of case number.
Correction of cast title.
Case number.
Case number. What is that case number should be?
What? Chhad de bina mo-
WPC.
This case file only.
Which number to be added? What is the wrong number?
The misplacing.
You don't know.
File the manner misplacing.
Please assist him. He may not be knowing. Can anybody assist me to that?
He says that file is misplaced.
File is misplaced. We'll have it after 2 weeks.
Manner, 2 days one.
Huh?
34.
Request of the petitioner.
So it should be 28,990.
28,990. It is 28,890 has come. Why? Typographical error. Learned counsel for the petitioner submits that the this petition number is 28890 of 2025. No, there is a 25. And what is printed is 28990 of 2025. The same needs to be rectified. Registry to take action in that direction immediately. Oh,
Item 35, WBC 31984 of 2025.
where it is put up, number 49. Order on I number 7. Okay. Yes, sir.
My item number 29 is missed.
25, I wanted to just point out one thing.
35. Yes, Mr. Mishra.
The writ petition was filed, my lord, and the disposal was sought for. Your lordship was pleased to direct disposal of the appeal within the outer limit of 4 weeks. But one fact that was not brought to the notice of this noble court is that the appeal is not yet ready for hearing. Even today, Order 5 Rule 20 application is pending for service of notice on some of the respondents on whom notice has not been served. This is what I only wanted to point out to your lordship. I am there, the contesting respondent appearing, but the notice is not sufficient. So appeal is not ready. That factor, my lord, may be taken into consideration. That much, my lord.
Appeal is not ready.
No, my lord. That is my instruction yesterday evening. And I have been sent, my lord, copies of Order 5 Rule 20 petition filed by them, wherein they want service of notice on some of the respondents also. So, my lord, I do not know. My lord, district judge has also sent a letter to this noble court, my lord, I think, which is flagged.
Is there a letter of the district judge?
That is at flag B, your lordship.
This RFA is of which year?
This RFA is of the year 2025, your lordship.
RFA means what?
Regular fast appeal against the civil court decree, original decree. Fast
They
appeal is
go to
preferred
the
for the land district judge.
96 appeal.
Exactly, your lordship.
96.
Then 100 comes before this noble court. Well, previously, as per valuation, RFAs were also filed for reasonable court. Now that is no more in vogue. By virtue of
Suppose
amendment,
if RFA is filed before this court, what you call it as?
it is also RFA.
It's also RFA.
RFA, but that is no more in vogue because the valuation, all the entire valuation has been given to the land districts. So no more further.
So this RFA is of which year?
2025, mine.
25.
Mine.
Why we argued, said like that actually?
That was disposed of in my absence, but I don't have a grievance. Only thing is that it's not ready.
Senior advocate, Mr. appearing for?
But in fact, I have filed an intervention application because I was not added as a party here.
Appearing for respondent in that RFA?
Yes, ma'am.
You are called as respondent in the RFA? Respondent in the pending RFA. As moved an application in I number so and so. I number?
I number 23397 of 2025.
23397 of 2025, seeking recall of the order dated 13 and 2025. He submits that his client was not made a party to the WP, and therefore he needs to be heard. First of all, who appears for the other side?
My friend, Mr. Dixit Krishna Shripad.
First of all, Learned Counsel for the petition.
I'm sorry. Should I understand corrected? I have made one mistake. I was opposite party number 13 and they are respondent number 10. But there no notice was issued. It was disposed of at the first stage.
First stage itself.
Mine.
But let your friend come. We'll call this after 2 weeks.
Thank you, Lordship.
Call this matter after 2 weeks. In the meanwhile, learned judge of the court below shall take all steps for accomplishing the service on the parties before him.
Your Lordship, Director, with regard to service of notice,
let him do that. Yes.
Obliged.
Your Honor, my item number 29 is missed, Your Honor.
29, please wait.
Item number 20 is a review petition.
Where were you? It was a review matter and you were not here. 29, you are appearing for the review petitioner.
You are. It was number 29. It was listed for orders.
What do you want to say?
Whether I am required to say something or order will be passed, I was just curious about it.
In 29, application in I number 373 of 2025 is filed under the wrong impression that there is a delay in filing the review petition. First off, the registry after verification of records has put a note that there is no delay. Full stop. Therefore, said application is disposed of as being unnecessary.
My lord, 37 revoked.
29 it is.
30.
Yes, sir. 1 second. Yes, sir.
Yes, Your Honor, I want to submit if it is required because the date is fixed for orders.
No, there is no delay. Registry has, there is no delay. You have filed review petition in time. Can you say something on the merits?
I am prepared, Your Honor, if the other side is ready.
Other side is, who appears for the other? Notice is not issued. Other side is ready in the matter. Go to 29. The cost is published. I don't understand published thing.
According to the name of the other side, law is not listed.
Emergent notice. Notice is ordered. Served on the other side.
Notice written, yes, sir.
Notice
After
written.
valid service.
Valid service done. But nobody appears for them.
Yes, sir.
There is nobody representing the opposite side.
Yes, Your Honor.
Let's wait for some more period.
Your Honor, it should be heard or it may be adjourned.
How will adjourn that?
Yes, Your Honor. If it is urgent matter, it may be expeditiously disposed.
Yes, yes. Call this matter on 10th of April. Yes.
Yeah.
Next.
My lord, 30 revoked. 30.
30. Where were you? 30. Tell.
Yes, Your Honor. 30 revoked. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30. 30
Pensionary benefit. This is review.
Yes,
What is the error apparent on the face of the record?
my lord, delay process.
Delay process का? Is there a delay process का?
Delay of 14 days. Opposite party appears. Where is your friend?
I am appearing for opposite parties 2 to 4 on behalf of the
2 to 4. One is who? One is state.
Yes, I am there.
Who is the OP number 1? Review or respondent number 1? Called as respondent or opponent? OP.
OP, sir.
Who is respondent 1 is yourself, Mr. G. Mr. G. In not shown. Correspondent number 1 name is not shown. Who appears for no notice is ordered.
Notice, yes, a notice was ordered.
Who appears for response? Mr. G, you have got notice for one.
For one only.
Learned AGA Mr. G on request accepts notice for one. First up, you serve copy. Have you served the copy?
Already copy sent.
And Sri so and so appears for other OPs.
Yes, Your Lord.
Will condone delay 14 days.
My Lord, I pray trying to file.
What is 14 days? There is a short delay of 14 days
Yes.
filing the review petition. An application supported by affidavit is more, taking its condonation. First up, delay is short and explanation offered is plausible. First up, in the above circumstances, application having been favored, the delay is condoned. Okay. Next.
Item 36, review petition 38 of 2026.
Yes.
Review petitioner, Your Lord.
But I have received the copy from my non-friend on only 19th.
On the same day, I have, it was Your Lordship had directed me to serve, I have served on that day.
What 9 I received.
If you want time, we'll give you.
Highly objection.
All
There is also there not objection as to.
How many days delay?
142 days.
142 days.
Your Lordship made delay because I was not party to the proceedings, Your Lordship. I filed a delay at a belated state only after I came to know Your Lordship. So what I pray here, my learned friend file his objection to the review petition. Delay may be condoned today, so that we can.
Will file objection.
He'll file objection. Pete. At the request of learned counsel appearing for this matter on 10th of April. Yes.
My lord, I have a small prayer.
Yes, sir.
In the connected, my lord, in the same case, 3 IAs have been filed. One for modification of the order dated 22/8/2025, and one for impleading him as a party, and another for condoning the delay. My lord, my submission, so far as those 3 petitions are concerned, I am appearing. My lord, my submission before your lordship is, in a disposed of matter, no IA can be entertained. The recent decision of the Honorable Apex Court, your lordship may kindly see.
Your Lordship may hear it or.
No. So far as review is concerned, that is separate.
It's the same.
No.
Same issue.
No, you are not appearing in those cases.
May not. I am.
My lord, may kindly see the
Yes.
judgment of the Honorable
IA
Apex
is
Court.
interlocutory. Means
Yes.
matter should depend.
Yes.
So I am that.
Yes. Please allow me. Please allow me to submit.
What I am praying, Your Lordship, let it heard at.
No. So far as
Because
IAs are concerned.
Together.
When do you want? When do you want?
Your Lordship had fixed it on.
No, that is relating to review petition.
No, it is tagged
IAs.
together. It is tagged together.
We can advance all these contentions on 10th. Ordinarily, courts have taken the view that interlocutory applications are maintainable only when the main matter is pending. If it does not pend, question of interlocutory nature will not arise.
Yes.
In such case, you can make miscellaneous application, this, that, etc.
And this is the recent judgment.
Your Lordship, grateful.
Item 37, review petition 44 of 2026.
10 days delay. First two cases 10 days, third one is 14 days.
Notice has to go. You are
10 days delay, 10 days delay.
Who appears?
No notice has gone, but because I am looking into the list only, I get to know this person.
You accept notice.
And can be delay may be
Notice
condoned.
is not ordered, is it?
No. First time.
First time. Issue notice. Let the counsel Mr. Das accepts notice for who are the OPs?
OP, he says that let the delay be condoned.
1 second.
He says, he submits my report.
Appears for OP number 1. Mr. G appears for OP number 2. First off, in review petition 44 of 2026, IA number 71 of 2026 is moved, seeking condonation of a short delay of 10 days. First off, the explanation offered is found satisfactory and therefore delay condoned. Similarly, in companion review petition number 45 of 2026, IA number 69 of 2026 is moved and it also is supported by an affidavit. It is delay too short, that is 10 days only, and explanation offered is plausible. First off, therefore application is favored and delay is condoned. Just call this matter.
Third one is 14 days. Third one is 14, 3 cases. 53.
Third one is 14 days.
Common order, man.
You can make common order. So all the 3 orders of 3.
Let it be
Also the common order, my lord's order.
let it be listed next week for admission. 10th.
Okay.
Next week, man, for admission.
Next week.
Next Friday.
All right. Right. 20.
Oblige.
Next.
Item 38.
I'll serve copy.
You serve copy.
Yes, ma'am. Yes.
Item 38, contempt 1094 of 2020.
Pursuant to my Lord's order, my Lord, dated 20th February 2026, I have filed the requisites on 24th February 2026. But another set of requisites is required, my Lord, for which I have filed today, my Lord, immediately.
Second set of requisites have been furnished. Registry to process. Yes. 1050. Call on 1050. Yes, next.
Item 39, WBC 3813 of 2021.
Yes, my lordship, in this matter, last occasion my lordship was directed to States Council to take instruction about if any monetary compensation can be given to the petitioner. In the matter, I am replacing my memory in the matter of appointment and disengagement of a book binder in the printing press. On last occasion, my lordship was directed that State Council may take instruction whether any monetary compensation can be given to the petitioner. 20th February 2026 order, my lordship.
Now he is 56-year-old.
Yes, that is also observed by this honorable. So now it is.
How many years of service he had put in?
For 4 years.
4 years. Thereafter?
No, my lord, rest is 4 years. Only in 94, he has appointed.
Give the date.
Yes, already 18 February 1994.
Yes, Mr. G, there is an order.
Yes.
My lord.
There is an order. Go to the earlier order.
20th February 2026.
20th February 26.
Yes.
Mohanty submits that he would confer with his official client as to whether some monetary compensation can be given. You take instructions and come.
I'll take instruction.
G. Mr. G submits that in terms of 20 February 26 order, he would he is yet to confer with his clients, official client. Like first, for that purpose, call this matter on 10th of April. Finally. Yes. Next.
Item 40, contempt 4110 of 2025.
Notice is served on that.
Yes, sir. Notice is served, but yes, sir, has not written.
Notice is served.
Yes, sir, not received.
Yes, sir, not
Yes,
received. Service returns.
Resettle. Await, yes, sir. Call on 20th.
Item 41, contempt 4258 2025.
My lord, voting is there, my lord, no, yes, sir, not free.
Pardon, my lord, item number 40.
40. This came running from the other court. Sit down. I'll take it afterwards. Take this. Pass over.
Item 41.
Next, 41.
41, my lord, noting is there, my lord, yes, sir, not back.
Here appears in which matter?
41.
40.
41.
40. password, 40 password, no? No. Yes, brother.
Notice has been issued, my lord, but SR not back, that is.
Wait, yes, son. Column, yes.
Item 42, content 5643 of 2025.
My lord, may kindly see order dated 13th February.
My lord,
Your lordship allowed.
beg pardon, my lord. Kindly allow me to present 1 minute. Item number 40, even if your lordship direction to notice has been already issued, but this had not been returned, and
You appear for whom?
I am appearing for the petitioners.
You are for the complainants.
Yes, madam.
You appear for contempt.
I am in item 42.
My lord.
Item number 40.
Yes, my lord.
Passed over matter. Yes, what you want to say?
My lord.
Yeah, the SR has not yet come.
No.
Yes, sir, we have to await the notice, service of service report.
Your lordship has specifically passed the order.
On 20 February 26.
May I read it, my lord? Issue emergent notice.
All that has happened now. Only service report has to come. It's a contempt matter, a serious matter.
Yes, my lord.
We'll await and we'll call this matter on the 10th of April.
My lord, the person who has been appointed is now going to be, his session will completed after 1 month.
After 1 month means when?
My lord, April last, my lord.
Last. So 10th of April we'll have this. Call this matter on 10th of April. Awaiting service of SR. Awaiting service of SR. Okay. Next.
Item 42.
42, my lord, notice was, my lord, on the last occasion, Lord Government Advocate was directed 2 weeks time was granted to file compliance affidavit. My lord, may kindly see last date. In the meanwhile, 5 date has gone.
Go to date next day.
One, my lord, one writ appeal is pending my record size. One writ appeal number 212 of 2026
is filed. Against this order.
Against the order dated 10/9/2025.
10/9.
Yes.
Which is your order dated
10/9/25.
So they have filed writ appeal.
They have gone writ appeal.
They will post that writ appeal.
My lord. My lord. WA number 212.
G submits that against the order whose violation is complained of, writ appeal number so and so has been filed.
212 of 2026.
212 of 2026. First of, in view of that, call this matter on 10th of April. No, next 17th of April. 17th of April. Okay. In the meanwhile, writ appeal prefers to be processed if there are any defects from the side of appellants, from the side of contenders. Okay.
Item 43, content 59747 of 2025.
Last order, then 22/1.
Item 53, that means DGC University matter matters. University went on appeal. Honorable Court was pleased to issue notice matters are directing to serve copy to my sister. I have already solved it. Would have been listed matters. Because of some technical problem, it could not be listed matters. Tomorrow probably it will be listed because memo has been allowed. Fact, the record concerning read petition have been tagged up in content petition. The office says that it should be with the writ appeal. Unless that can be writ appeal cannot be listed.
That writ appeal is tagged with this content matter.
These read petition matters, out of which that content petition arises matters, we prefer read matter, read appeal. But so read petition matters, the whole total record concerning read petition has been tagged up in content petition. That should be fed to the read appeal matter. That is what means office is unable to list it.
We'll do that so that at least something will happen.
Yes, ma'am.
Registry to dissociate writ petition papers records from this file, from these files. First of all, let the senior panel counsel appearing for the university submits that against the order in question. Writ appeal has been filed. Writ appeal number
188 of 2026.
26 has been filed and it is likely to be taken up for consideration before long. First time, in view of this, call this matter on 10th of not 10th, 17th of April. In the meanwhile, you have to do something.
But that
Otherwise, we cannot wait endlessly.
Notice is already issued, my lords, by London sister appeal.
Delay application.
Delay application, yes.
Item 44, contempt 6183 of 2025.
54. 54, there is a compliance affidavit.
The compliance affidavit is what?
It's a matter relating to
compliance. Let us examine just eyewash compliance or real substantial compliance.
my lord. 8/9 to 2025. Your lordship disposed of the writ petition with a direction. In the above circumstances, petition is disposed of. Time for compliance is 8 weeks. P2 is to inform the result of the consideration of the petitioner in a writing to this within said period. It is open. So and so. My lord, the written
Order dated.
order dated, my lord, it was of 17/11/2025.
How much time was given? Within what period to be? Go to the order.
8 weeks.
4/2/26. 4/2/26. Huh?
My lord.
No, not 4/2. Order of the writ court. 8/9/2025.
8/9/2025, order was passed. They have disposed of the, they have passed a speaking order on 17/11/2025.
Why that was not served to other side, even when there is a direction?
It was,
Unless that is served during the compliance.
my lord, the copy forwarded to the memo. In the memo, it was written.
Now, how that is forwarded
to the
sent it? There should be some accountability.
Barcode, my lord, it was there.
Otherwise, we'll impose a 5,000 rupees cost so that next time everybody will do.
Speaking order was, we have filed compliance.
No,
Speaking,
compliance is passing order and informing the order.
it was, they have informed.
No, where is that?
My lord, lordship, may kindly have a look to.
No, that only mentions
No. It
how
is,
it was sent, which is the postal number, what is the speed post, who sent it, to what address, how we should know.
no, it's not there,
Otherwise,
but
they will
in,
pass order and keep it in their drawer.
no, my lord,
The
it-
citizen will come to know.
in the memo, they have sent it.
Huh?
In the memo of the order, page 7 of the compliance.
Compliance is a rejection. Memo number what?
Memo, page,
Ah.
page 7.
Annapurna.
Yes. Annapurna Paul, PT, at Government SHS High School, so and so, for information.
17/11/25.
Yes.
How that was sent? So casual, these officers.
In memo, they have sent to all.
Huh? How they are sent? Forwarded to
Annapurna Paul is the petitioner.
High school so and so. For information necessary action. Where, how it is sent?
My lord, it was sent through office. Office
What is the
office
order?
peon, my lord. Order was,
Is rejected.
my lord, careful,
That in this-
whereas after careful consideration of relevant facts, I'm giving you now. Lay down.
This complaint alleges violation, non-compliance of the order dated 8/9/2025, whereby complainant's WPC number 22857 of 2025 was finally disposed of. First, the operative portion of the order reads as under. Next paragraph. After service of notice, learned AGA appearing for the contemptor submits that in terms of the above order, the claim of the petitioner complainant having been considered is rejected while order dated.
Yes, that one.
Huh?
17/11/25.
17/11/2025. First of all, I am told, this court is told that a copy of the order has been served on the complainant as well. First. Next paragraph. In view of the above, no purpose would be served keeping the complaint pending. And therefore, the same is disposed of, reserving liberty to the complainant to assail the rejection order elsewhere in accordance with law. In that connection, all contentions are kept open. Give a copy of the order to his.
May I pray, Lord, see? Next date, then I can say whether that is complaint or not.
This matter is contempt, is matter. Well, other day only I wanted to dismiss it and you insisted that it should.
For that only, I am not getting the copy, or Lordship only keep.
You have heard, don't waste our time. Yes, next.
Item 45, contempt 6184 of 2025.
Some time may be given, my lord.
45.
Yes,
What was the order? When order 21/8,
my lord, they have,
21/8/25.
yes.
What
They
was
have-
the order? Go to the order. Let us see how it is.
In the above circumstances, the writ petitions are disposed of in terms of the cognate case of the having heard law and counsel for the parties and outgoing materials of
Appointment to be given to the concerned person. It has not been given.
my lord, rehabilitation assistance.
Correct.
Let's
But
give me-
21/8/2025. How many days the citizen should wait
Lordship may give me,
even after succeed?
my lord, Lordship may, they have asked so many, 6 weeks time they have asked for. Lordship may give me 2 weeks time only.
Call this matter on 10th of April, finally, for reporting compliance, failing which stringent action may follow against the contemners, which may include arrest and detention. Yes,
my
please.
lord.
Item 46, contempt 6202 of 2025.
May I please, my lords? The operative portion of your lordship's order at page 27, my lords.
LIC over here.
LIC, my lord.
Here in this matter, I am appearing for LIC. We have complied with your lordship's order.
No, my lord, there is no such
One
objection.
second, let me submit.
My
Let
lord.
us. Yes.
My lords, kindly see today's affidavit. Your lordship direction, my lord, kindly see.
Where is the direction?
Lord, I am showing it. to
Page
your-
27.
Page 27, your lordship is seeing. Lord, the writ appeal is pending. Our writ appeal is pending. Still then we have complied with your lordship's order.
Let us see.
Like-
When any interim order is obtained in the writ appeal,
No.
then a contempt happens.
Lord, page
Yeah,
27, your lordship is seeing.
These writ petitions are allowed. A writ of shall be issued backing the termination of allotment with the writ of mandamus to formalize subject allotment by executing and registering required conveyances in favor of petitioners within 8 weeks after accepting petitioner's remittance of all amounts, including additional levy of 10%. Make the remittances within 6 weeks. This order is made on.
Lord, in fact, pursuant to your lordship's order, though we preferred an writ appeal, but in the meantime, we have issued an allotment order in there.
No, order. Kindly read it. What
Lord, I have read. Conveyance part, Lord, your lordship will definitely consider one aspect. Conveyance part, let me say, Lord, Apartment Ownership Act is the act which governs the issue of allotment of a registration of conveyance in favor of all the allotment of the state. Now, the virus of that act is under challenge. Throughout the state, the state is not permitting registration of a single conveyance in favor of a single allotment.
you present it and you produce that non-registration endorsement.
That I can do.
Yeah.
That I can do. That's the problem. We are not able to do it. But allotment orders we have issued. Lord, the rest part, your lordship may give us some time. We'll do that.
Learned senior advocate appearing for the contempt. Which contemners?
But LIC of India, your lordship.
Contemner. How many are there? Go to this first item. Sorry. The senior advocate, Mr. Rattu, appearing for contemner, submits that already allotment in terms of the order whose violation is complained has been made. Although, he further submits that the issue of executing and registering the conveyances needs to be deferred in view of pendency of certain disputes relating to this aspect of the matter in other cases.
And state is not permitting.
First of all, he adds that the registration is not being done, even if conveyances are presented for the before the sub-registrar. First of all, he submits that the client is ready and willing to submit the conveyances for registration if reasonable time is granted, subject to the same being registered at the hands of the jurisdictional registrar. First of all, in view of this, call this matter on 10th of April. First of all, in the meanwhile, when do you say? First is some next month, it was 17th of April.
I understand the embarrassment, Lord. I understand the embarrassment with great humility, Lord. Your Lordship, give me 1.5 months time, something like that, Lord. So that
My lord, may I submit, my lords?
Registration,
My lords, may I submit, my lords? We have submitted the DD. They have returned that the writ appeal is pending. Now, my lords, when the matter is before your lordship, my lords, they have issued a provisional allotment letter, which is already in my favor since 2014, my lords. Now, my lords, today morning I have received my lords, conveyance. Let it be on 17, my lords, not more.
We need some time. Otherwise, Ratha will not ask much time at all.
My lords, on the next
special paraphernalia, Lord. That's
first of all this matter on 30th, no. 24th of little more.
Vacation.
8th May. 8th May 2026. In the meanwhile, the execution and execution of the conveyance and the presentation before the sub-registrar for registration shall be accomplished. First, if the conveyance is duly presented for registration, the jurisdictional sub-registrar shall register the document unless there is any stay order from any court.
Right. Can I just say, more indulgence of the Lordship. That allotment is provisional because our writ appeal is pending. Provisional allotment we have issued because we have filed a writ appeal rightly or wrongly. That's pending.
No, what you can do instead of calling it provisional, you can make that allotment subject to outcome of the.
That would be great, man. That would be great.
That you should do.
That should have been done. Lord, as your Lordship know in the office administrative process, they usually commit these mistakes. Therefore, they have written a provisional allotment. It's only.
I am the petitioner, sir. I am a lawyer, I am not very. But I can, they have sold many flats at that moment. Have they not registered all those flats?
But at a point of time, let us not buy this.
Ban arises when?
Let them show the ban. If there is a ban,
therefore we made it now. So that now the registrar, let them present it for this one. You have to do this.
But we do not have any personal agreement.
Right. They are authority, that's all right. We understand.
Is there any question of personal agreement?
No.
They are themselves raising it.
All right. They will do that, no? All right.
8th of May, madam.
8th of May. You do some, Mr. Radhatho, unless there is a stay.
Not at all, not at all. I'll advise them. I'll advise them. Need not invite trouble.
Yeah.
Item 47, Contempt 6296 of 2025.
Niyant.
Let's and last one.
Lordship.
Last one. No, complaint.
Lordship.
Only council appearing for the
kindly have a look.
that the sub-collector has done its
order dated 10/11/2025.
10/11/25 is the order.
Is the order. In the above circumstances, the petition is disposed of, reserving liberty to the petitioner to make an appropriate comprehensive representation coupled with all evidentiary material in support of his claim to appeal one, and if one be made, the same shall be considered, and result of such consideration shall be intimated to the petitioner for 4 weeks. My lord, thereafter, my lord, your lordship may kindly have a look to Annexure A to the compliance. In compliance to the
in compliance with the order of the Honorable High Court in WPC number so and so, filed by Lalit Mursana, Principal in charge of Karillo Patna, College Karillo Patna, the salary for the period from July 2025 to September 2025 has been drawn. Further salary for the period from October 2025 to January.
Able to see the document. Which is that document you are reading? Do you have a hard copy of that with you?
Yes, yes, madam.
Please give. Compliance affidavit.
Yes.
Why you complying? There is one copy of your WPC.
No, sorry.
Compliance affidavit is not filed.
Yes.
Give that copy.
It was filed on 12th of March 2026. He filed.
Give your copy. Just I look into. Now order has been passed. Mr. G.
My lord.
Whether order has been passed in terms of this writ order.
Yes. Your lordship directed to give us a representation, and accordingly salary whatever is pending, my lord, it is to be disbursed up in his favor, my lord.
Is it done?
It is done. What the compliance affidavit is.
Where is the compliance affidavit?
I'm just passing it over, my lord.
Do you have copy of that with you?
No. I am having. I am having.
Yeah.
No.
When today, whether it has come.
Online.
No, the hard copy is given.
That's annexure A, your lordship may kindly have a look. Huh? Uh-huh. कहा दो उसको कहा दो उसको.
Yes, on 2/3/2026 it is paid to you. On March 2. Perhaps your client has not told you that you are fearing that you would.
No, my lord. This is your lordship can have the order has been passed by Lord and Director to disburse the salary for 7 months from July to January 2026.
Yes.
But instead of doing that, he released salary for 3 months. And that's why your lordship have called for your director for personal appearance. Your lordship can have a glance at the order, the last order. Your lordship can have done.
July 25 to September 2025.
My lord.
Has been drawn.
Has been drawn further. Slowly. Why are you doing like that? Are you going to run away?
No, my lord.
To salary from October 25 to January 2026.
My lord.
Is here been paid, sanctioned and released too.
Released.
Only 3 months have been. The Lawrence sticks to his own stand. He has only released salary for this month of 3 months, that is from July 2025 to September 2025, and he has not.
Read further. Kindly read para 6. Slowly, without tension, without running away. Read slowly. You may be right also, we don't know. Read slowly.
6.
Page 7.
That it is only submit that in compliance.
No, page 7.
Page 4. page 4.
Annexure A.
Annex 3. That in compliance with the order of the Honorable High Court in WPC number 307/54 of 2025 filed by the Sri Lalit Mohan Samantara, Principal of Koilapatna College, Koilapatna, the salary for the period from July 2025 to September 2025 has been drawn. I have received it.
Read.
Further, the salary for the period from October 2025 to January 2026 is hereby sanctioned and released to Sri Samantarai.
Yes.
But I have not received it.
No, they are saying that there is always this government works like a snail. Have you seen snail? Government works like a snail. It will not run away like this, like you, not like PT Usha. It was very slow. Don't understand. They have made this order. When money will reach his account, Mr. G?
Yes.
When money will reach his account?
My lord, that
yes,
definitely within a week.
We'll record that.
Yes.
And drop the proceeding.
Yes.
All right. Complaint alleges violation, non-compliance of the final order date. Hey, go to the order. Don't change when I'm reading. Complaint alleges violation of the final order dated 10/11/2025. Entered in complainant WPC number 30754 of 2025. First up, it related to settlement of certain monetary claims of the complainant employee. First up. Next one. The after service of notice, the contemptor has filed a compliance affidavit dated 12/3/2026, enclosing the office order number 2761 of 61 dated 2/3/2026 at Annexure A. Full stop. This compliance order reads as under. Next paragraph. You have put the flash. Just looking to. Next paragraph. Learned counsel appearing for the complainant submits that though such an order is passed, money has not reached the bank account of his client. First off. Learned AGA in reply submits that within a week, money would be credited to money by way of salary dues for the period between July 2025 to January 2026 would be released.
The salary.
However, September is paid.
No.
From September, I have received.
From October.
September. But from October to January 2026, I have not received.
October to January 2026 would be credited to the bank account of the complainant. First one. If not credited, the concerned officials shall pay rupees 10,000 to the complainant in addition to paying the amount in question. First one. 10,000 going so within 2 weeks. Within 2 weeks, reckon from this day. First, with the above observation, the complaint is dropped with liberty to the complainant to move afresh in the event assurance given today. She is not compliant. Next.
Item 48. Contempt 65 type of.
Madam, on behalf of Mr. Mahabat, I'll pass over.
SR not received.
Not received. 10th of April. Yeah.
Item 49. Contempt 643/25.
Compliance affidavit not filed. Not filed. Compliance affidavit is not filed.
3925.
Service of police is done when?
Two dates is like.
Sir, have not come.
Yes.
Compliance has not come.
Compliance
Give me some time.
Learned Chief, Mr. Learned AG, Mr. G appeared for the contempt submits that seeks a short accommodation. First of all, on 10th April. Yes,
Item 50,
for reporting compliance.
contempt 7 of 2026.
May it please, ma'am.
Yeah.
But they have filed one complaint, so cause, declared to so cause manual, that writ appeal is pending and delay on question of limitations, notice has been issued, manual.
There is a writ of apex court. Generally, this lies in the contempt court. If appeal is pending, not to take the discretion lies in the contempt court. I am saying it again. Otherwise, they may say in every matter we have filed appeal and therefore
Yes, ma'am.
contempt not be taken. Yes, sir, Mr. Patanaik.
Notes as on date, notice on the limitation has been sent on, has been orders were passed on Tuesday.
Learned panel counsel Sri Patanaik submits that the order whose violation is complained of is put in challenge in writ appeal number
213 of 2026.
26, and the DB has directed issuance of notice last Tuesday. First time. In view of call this matter on 24th. No, 24th. Because appeal is pending. No, notice is ordered is that for next.
Actually, this is compulsory
Next.
Item 51, contempt 17 of 2026.
62 also, same.
Same.
My learned friend is appearing.
62. Same order.
Same order.
Can we call those together?
But
Yes,
the
ma'am.
condonation delay has not been intervened till now. I have made a mention and that is to be listed coming week.
Call the,
And writ appeal number is
in that writ appeal, what?
405 of 2026.
Yeah. Change that. Huh? Yes, 51.
My lords, in this writ appeal, notice had not even been issued. It is going to be listed in the coming week, my lords. Made a mention.
This is not appointed.
Those will be to be issued. Whether it be. Okay. Call.
Item 51, contempt 17 of 2026.
Sir, in item 51, there is a IA, including the party is opposite partner, the headmaster of the school. This he is not allowed.
For what?
As for the SR, there is a defect of including the party opposite part number 2 as headmaster.
In the content matter.
Yes. 66 of 2026. You are going to find.
One so cause affidavit was filed on behalf of the opposite party number 3. Worship disposed of the writ petition on 1/9/2025 by giving the following direction. In the above circumstances, the petition is disposed of with liberty to the petitioner to make a representation of the kind of Annexure 7. If such a representation is given, the same shall be considered by the jurisdictional opposite parties within the outer limit of 8 weeks, and the result of the consideration shall be communicated
to them
in writing. Third, in compliance to the said order, my lord,
that's been done now.
so cause was filed.
It is not complaint, madam.
Not yet complied.
No. As per my instruction, they are not complied the order.
Who has to comply that order?
The complaint.
Compliance has been made.
District Education Officer, Jajpur, and headmaster of the professor.
Master will do. Some one person has to. It's not an institutional decision.
No. Main is the District Education Officer, Jajpur.
Yes, sir, Mr. G.
My lord, this was filed on
to 2019 to 2026, he filed. Whether it is there on record or not.
Went into his compliance, sir.
It probably it is. The appeal of Srimati Sahu, this is the letter of the director.
Yes, 9/2/2026. Director has taken the decision. Jurisdictional authority. I have used the
Term
jurisdictional authority.
Yes. B/3 annexure, your lordship may kindly. Srimati Minarani Sahu, PET Corporation High School, Duburi, has filed an appeal before the undersigned on 27/9/2019 pursuant to the liberty
This was
grant.
for regularization.
My lord.
What have you done now?
And the appeal of the Srimati Sahu of the written contentions of the headmaster so-and-so school by letter so-and-so report from EO by letter have been examined. It is revealed that the petitioner, while discharging the duty, Kapaleswar Nodal High School, Duburi, has proceeded on medical leave from 1/8/2018 to 31/1/2019, and her joining was not accepted by the headmaster. The DO Jajpur and the headmaster so-and-so school in their written submission submitted.
Which annexure you are reading?
B/3.
B/3 is which year? 2020.
20.
Thereafter, all this has happened.
My lord. Thereafter, nothing has been.
Therefore, compliance has not been done.
Lordship, give me some time.
288, Mr. G, representing the contempt. Submit that if a short accommodation is granted, you would confer with the clients and come back with hopefully come back with compliance report. First of call on 10/4. Next.
Item 52, content 58 of 2026.
Service is done.
Yes.
Will you take notice for them or SR to come?
SR to come, my lord.
Wait. Arrival of SR. Call on. Yes. Yes.
Item 53, contempt 116 of 2026.
May I please, Lord?
Yes.
Non-compliance of the order dated 13/8/2025. Notice was issued.
SR has not come.
Yes, sir, notice return, sir, from opposite party 1, 2, and 3. Up to
1, 2, and 3. Yes, Mr.
Lordship, give me some time.
Mr. G, representing the contemner, seeks a short accommodation, hopefully for reporting compliance. First up, call on 10/4. Yes.
24 also same, my lord.
24 also same. 50%. All right, sir.
Item 55. Contempt 231/2026.
Notice was issued on 4/2/26, my lord.
In the meantime, the same has been complied, my lord.
Complied?
Yes.
But problem is compliance orders are not sent to the citizen at all. All citizens are treating as servants.
It is letter 7/3/2026.
Give that.
I'm also receiving the same too.
When she entered into service?
Entered into service on letter 18/6/2007, my lord.
Guest lecture.
Full-time research person. Not bad.
No, they have rejected. You challenge this order. But even that reasoning is not good. But what to do? I'm in contempt jurisdiction, therefore I cannot take action. Reasoning is, see, he did not go to the court. And others went to the court.
I'm
That
reading.
is there.
I'm reading out the even say Srivastav case is also not taken. I'm reading out.
Sri Lalita.
Sri Lalita and Srivastav also.
Srivastava.
Yes.
Both the matters. So when one set of people go to court and get the order,
Arvind
the benefit will be
Arvind
extended to them
Srivastav
also.
also speaks like this one.
Challenge that order. Well, complaint alleges violation of the final order dated 2016-2025, wherein a direction was issued for consideration of complainant's case for regularization of service. First, after service of notice, compliance report has been filed. Compliance is reported saying that void order dated 7/3/2026, claim of the complainant having been considered is rejected. First, a copy of the order is placed on record. In view of the above, complaint is dropped with liberty to the complainant to challenge the said order elsewhere in accordance with law. First off, in that connection, all contentions of the party can go. Next.
Item 56, contempt 259 of 2026.
Yes, my lord. They have alerted for interview. Those were directed to halt the commutation of value of pension till the next date of case. But we have alerted that they have not stopped that commutation value till now. And till the last date.
I will come back afternoon.
Lordship, kindly see your Lordship's order 13/11/2025.
Yeah, issue amendment.
The rate. Paragraph, application highest offenses are supported by affidavit are moved saying there is urgent investigation of the Client Counsel for petition submit that the identical matter of the coordinate bench has granted interim protection in WPC number such and such. In the meantime, that has been disposed of.
Let WP
minor.
Disposed of saying?
Minor. Saying they have to file another application challenging that commutation value pension in the rule 7 of the commutation rule.
So what should be done in this matter?
In this contempt, this is my lord contempt.
Like to that judgment.
Now the contempt matter is going on. He is showing the date. The grounds of that rate and this rate is perhaps not same. I have verified.
I am referring that grounds are passed that order.
I rely on certain grounds and in that petition.
Anyway, we had given you interim order.
That has not been complied with.
No, that question will not arise because we gave this order in the light of another order.
Yes.
That order has gone now.
But I had not relied on that order. That was I relied on certain order that person has not been disposed of. Perhaps
recovery was halted.
Yes.
Recovery is being paid to amount is being paid to whom?
Amount is paid to here is commutation pension. They are taking loan from his pension amount, that 40% loan. He will from month to month, he will pay the government.
That was halted.
That was halted by your lordship's order.
Now your recovery is being made.
recovery is being made.
Because of dismissal of other connected matter.
No, the dismissal of the connected matter, a recovery has not been made. Only communication has to the State Bank to stop the reduction.
No, what happened in WPC 25294 of 25?
25, that is disposed of. That is disposed of.
By another judge.
Minor, the coordinate bench.
Their case is separate. Perhaps prayer may be same, but the grounds are different.
No, that's the ground on which we had given notice.
Yes, I am. My ground is their method of calculation is wrong.
Huh?
They have adopted certain method regarding computation of commuted value. That is wrong. My ground is that. But in that case, they had challenged that from 12 years they enhanced to 15 years.
That is merit of the case of the
That is separate ground. And they had
merit. How content will we can hear the main matter.
This is not now. The main matter is not here now. This is contempt matter.
Contempt will drop because the order which we have given to you.
My lord, your lordship order was not carried out intentionally, and this is interim order. If they would have carried out the interim order, then finally what would happen? That is separate.
No, not separate.
Yes, finally, I would have paid the entire amount that has been recovered. But this is a content matter. They have not carried that out, complied the same.
Heard.
In the need
counsel for the parties. First of all, complaint is violation of the interim order dated 13/11/2025, whereby the recovery was stayed, keeping in view an interim protection granted in WPC number 25294 of 2024. First of all, learned panel counsel, Mr. Patanaik, Mr. S.K. Patra appearing for Accountant General submits that the said WP has been disposed of.
Not this WP.
Not this, another WP. The said WP, that is 25294.
No, that has been
disposed of.
No, that has not been disposed of.
Huh?
That is pending. 25294 is pending.
The order I have handed over to Lordship.
Why are you speaking like that? I am holding the order of disposal.
That is my case, 25294.
Huh?
2594-24. That has been disposed by the coordinate bench.
25294 of 2024. The said WP has been disposed of by a coordinate bench of this court while order dated 1/12/2025. In the light of the order passed in another case, that is WPC number 13237 of 2025 and connected matter. First off, in view of this development, we can't assume that there is a violation of the interim order. Intentional violation of interim order. Come on, as rightly contended by the learned panel counsel. First off, in view of the above, this contempt proceeding is dropped. First off. However, it is open to the complainant to make non-compliance of the said order a ground in his pending the writ petition. Okay. Place it in our record. Yes.
Item 57. Contempt 281/2026.
That execution case of the Supreme Court's order. The Lordship may kindly come to 16/1/2026. Issue emergent notice through police to the contemptor returnable within 2 weeks. Steps for which shall be taken by the petitioner within 3 working days, which has been done. This important is the next paragraph. the police is directed to serve the notice scrupulously and submit its report immediately, failing which punitive action may follow against the concerned police.
Yes.
Flagrant violation.
What they have done? Well,
They have-
police have not served.
No,
Yes,
nothing.
Sir, my lord. The 57 is here SR not received, my lord.
No, we will take action against the
ma'am.
police.
And personally also, I have contacted the person. So they have in the process to comply the order, but need some time, my lord, because they have given the details. Those were the incumbents from 1978 to onwards, my lord. Apart from that, the order to comply needs some more time, my lord.
No, that you can seek in this court, not in contempt court.
To
This
comply
contempt court cannot-
this honorable court's order.
Huh? No, why police have not reported service?
Lord, the noting
court,
in the SR not received, my lord.
This court, while order dated 16/1/2026, had said as under. Written. Next paragraph. Learned counsel appearing for the contemptor submits that despite a threat by this court in so many words, comma, the police have not effected service, not submitted the service report, nor have they effected service otherwise. First one, this is a serious lapse on the part of the police, comma, if allegation is true. First one. Next one, in the above circumstances, who is the deputy superintendent of police?
This is my lord Mayurbhanj.
There are three parties. One is Capital Police Station, one is Chandrasekharpur Police Station, one is Karanjia IIC.
All they come under which police station?
They will come under.
They are in
DG
different
police.
part, my lord.
DG police.
Different part.
Karanjia will come under the Karanjia DSP,
This is on Mayurbhanj.
Mayurbhanj district. And Bhubaneswar Commissioner of Police, Capital, and Chandrasekharpur.
In view of the above, there is Inspector General of Police above them.
Inspector of General Police above them.
Which range?
Cuttack will be central.
Cuttack will be central.
Cuttack will be central.
So again, they will be different.
They will be different.
In view of the above, the Director General and Inspector General of, whether there is such a post, DGP, IGP?
Yes.
DGP.
Yes.
Director General and Inspector General of Police. Bhubaneswar.
One is Bhubaneswar, one will be Mayurbhanj.
There is only one Director General and
One
IGP.
Director General.
One is at address at Cuttack.
No, one DG,
One
IGP,
DGP, one DGP.
That is at address at Cuttack.
Only DGP or DG, IGP?
No,
DG.
DGP.
DG, IGP. It is like that, na? Because of Prakash Singh case, Director General, come Inspector General of Police, is directed to hold inquiry as to why the above lapse has happened and submits report to this court in a sealed cover.
Lord, 61/2026 order
Yes.
was duly communicated by this office to the Additional Secretary, Principal Secretary and DFO.
How? Through police?
No, my lord, directly notice.
We directed police notice, na? Police have to do their job merely because IAS officers,
This
they are
might not have been
communicated.
communicated because this order has been communicated to the Principal Conservator of Forest, DFO and the Additional Secretary. my lord. This
By
has-
whom?
By the AG office. my lord.
AG office makes no, we never told you to do all that. But it's not.
We have
correct.
communicated the order, my lord.
We do not know all that. We asked the police to go and stand in front of them.
Well, because of that particular day, opposite party, though it has been passed the order against the person concerned, so far the DFO is concerned. Because none is for the OP contempt.
These IAS officers think that they differently think that. That's the reason.
And to comply this
on or before. 10th of April 2026. First, call this matter on 10th April. First of, registry to send a copy of this order by speed post and email to the Director General, come Inspector General of Police, Orissa, Bhubaneswar. for immediate action.
Lord, that is not a Bhubaneswar. This will be Kata.
Lords, I have a further submission. I have filed a petition since this is an execution case. I have filed another petition for attachment of salaries. That is in the record. I am just bringing to the record.
So for the compliance of the order, as it appears that they are in the process, needs some time.
That we can tell to the writ court, not to the contempt court. I have no power to extend the time. Writ court can do it. You file application under 148 of CPC, then the court will look into that. But as of now, nothing has been done. Yes, next date that may happen. If they do not do, we'll stop the salary of the Director General first, then rest of the people. That's the way. Otherwise, things will not move.
Your Lordship may record that I have filed a petition for attachment.
Not necessary. Let it.
Yes, if it a little bit done.
Item 58, contempt 330 of 2026.
On dated 11/8/2025, Lord, WPC number 21895, my lord. Order dated 11/8/2025, my lord.
No, this is for the first time,
Issue emergent notice, police notice. Same format. Yes, to the contemners. Yes.
Obligement.
Yes. Returnable on 10.
Item 59, contempt 386 of 2026.
59, my lord, it's compliant.
No. Compliant.
Yes, Lord. Already he filed the hard copy.
You have to give copy to him also. He should know at least what has happened. Although he has no voice, because contempt is a matter between
today I am receiving. Today I am receiving.
But still they should know. What was the order?
Only to time, granting some time for this purpose. To comply the order of my lords.
No, what was the order?
The order dated 12/9/2025. Wherein this Hon'Ble Court has been pleased to pass an order at page
in terms of so. What you have done?
Needs to comply some breathing time. For that we are filing a petition. We are in the process.
Learned AGA Mr. Monti appearing for the contemners seeks a short accommodation for reporting compliance. First time. Call on 10/4. Yes, finally. On 10/4, if nothing happens, then
yes.
Next.
Item 60, contempt 387 of 2026.
Same, my lord. We need some time. Same both are them the same. 10/4.
Item 61, contempt 420 of 2026.
We are appealing for the container. I have already filed the reply. Also copy.
61.
Is a 61.
What is that reply? We needed compliance, na?
My lord, guest faculty, they have challenged the notice for advertisement. Your lordship has directed that they should be allowed to continue. Here they say that they have been allowed to continue. They said that the classes are not being given. But that they have given a referendum. They said that that is violation of the.
They have not allowed me to take the classes, my lord.
Continued means what?
Continue, your lordship. As much classes, your lordship knows the regular teachers are there. After accommodating them, then the rest of the classes will be given to them.
Now, are they all right? Continued means, are you going with the remuneration to them?
No, my lord. Your lordship knows it is temporary guest faculty. As the rest of the classes, that is after accommodating the regular teachers, if the extra class left, then they will be given.
Your lordship will.
Your lordship knows the guest faculty, temporary guest faculty for 1 year. The 1 year appointment, your lordship knows. Your lordship allowed them to beyond 1 year, they have now being allowed because of lordship direction.
Shall we continue with the same terms and conditions with the pendency of the petition? Same terms and conditions.
Yes, sir, allowed.
Earlier, what you were...
Also, you also have given the detailed reply. You also may call for the industry along with that reply. Given that the classes have been given, they said that some more classes they want. They have given the representation. Representation, lordship. They
Your lordship, on this matter, on 10th of April. Yes.
But only one submission, my lord. Before passing the interim order,
like the petitioner has got some remuneration as per the classes. After passing of interim order, intentionally they are divide the petitioner to get the class.
Contempt will see
Yes.
if that is true.
Yes,
He
there
knows.
is a obliged.
Item 62 has been adjourned. Item 63, contempt 461 of 2026.
This is a matter for non-compliance of the order dated 10/9/2025. No, after lordship.
We have filed
this issue.
compliance order, my lord.
What was the order?
Order, my lord. Directed to the
Consider the representation.
BO to send the necessary records to opposite partner 5 for release of a GPF amount.
Oh,
What
the
till
reports
to-
are sent now.
No, my lord.
No.
In the meantime, they amounting to rupees GPF 1,30,000.
No, my lord. My
53.
GPF amount is 15 lakhs or some odd, my lord. But as per his instruction, my lord, today morning, they have not released this amount. As per-
But this 1,35,000.
Not released. 15 lakhs, my lord,
Where
GPF
is the
amount.
order? It may be 50 lakhs. But where is the order quantifying the money?
No, could not quantified. And your lordship directed to instructed to opposite partner 4 to do well needful by sending all the necessary records or
That's
to opposite 5.
They have sent.
Could not send to today.
Have you sent all the records?
My lord, records have been sent.
When?
My lord, this payment has been made on 13/1.
No, we have not directed you to pay anything. We have said petition is disposed of fixing a period of 8 weeks for accomplishing the task and to inform results of the assessment to the petitioner in writing. What was the accomplishment? Taking effective steps by OP5 in we submit that unless this court intervenes, the papers would not move from one office to another.
Yes, ma'am.
Should not mean English in our court. Learned AGM Mr. Munti appearing for the OP is very fairly certain that he would instruct OP number 4 to do the needful by sending all the necessary records to OP number 5. And that the OP number 5 shall take the decision in accordance with law within an outer limit of 8 weeks. We have not mentioned any amount at all. What have you done?
But in the meantime, they have processed and released the amount of 1,35,000.
Whether records have been sent, all the records have been sent.
Yes, my lord. Though the date has not been specified. So for the amount of disbursement, it was 13th January, my lord.
Where is that?
I have given my.
Well,
Please give copy of that.
I have given the copy, my lord.
No, totally I have to see now.
That I have filed, my lord, once.
You have filed already. See whether a copy is filed. Compliance.
It I would go. Comply करते हैं सोचा दे
1,35,053 has been paid. Your claim is 14 lakhs.
Near about 15 lakhs, my lord.
15 lakhs. You fight that litigation. But this is in the contempt.
This is GPF amount, my lord.
Correct. This court wide order dated 10/9/2025 entered in complainants WPC number 24627 of 2025 at para 3 has observed as under 2 and 3 has observed as under. Next paragraph. The complaint is that this order has not been complied with. First one. After service of notice, the contemners have placed on record a copy of letter dated 12/3/2026 sent by Controller of Accounts Odisha to the Office of the Advocate General. First one. unnumbered para 2 in the said letter reads as under. Next paragraph. In the above circumstance, there is substantial compliance with the order whose violation is complained of. And therefore, contempt is liable to be dropped. Contempt proceedings are liable to be dropped, with liberty to the complainant to work out remainder of the grievance elsewhere in accordance with law. First off, in that connection, all contentions are kept open, ordered accordingly. This good. Take this. Next.
Item 64, content 575/2026.
Please, my lord.
Yes.
My lord, they have filed a compliance affidavit, copy of which has been given that they have sanctioned the increments.
So we'll drop the proceedings.
The details, my lord, I have given the details also.
Complaint alleges violation, non-compliance of the order dated 9/10/2025 entered in complainant's WPC number 27083 of 2025. First off, next paragraph. After service of notice, the contemners having entered appearance to the learned AGA have sworn to a compliance affidavit dated 10/3/2026 by sanctioning and releasing the increments.
Not released. Not released.
Sanctioning.
Sanction. Only sanctioned.
Yeah. Sanctioning the increment. First off, learned AGA Mr. Mohanty submits that since sanction is already made, release would happen in due course. First off. Next paragraph. In the above circumstances, this contempt proceeding is liable to be and accordingly dropped. First, if there is any other grievance, it is open to the complainant to work out the same elsewhere in accordance with law. Okay.
Item 65, contempt 628/2026.
65 complaints affidavit we have filed.
What is that compliance? What was the order?
Order was
consideration of representation.
Yes, ma'am.
In the right of state of Kerala versus Padmanabha, the interest on delayed payment.
Yes, exactly.
What have you done?
Now, can I have a glance to Annexure 2 million?
Go to complaint.
18%. This was the interest at the rate 18% for a delay in payment. This is order dated 22/1/2026.
22/1/26.
Yes, ma'am.
You have paid the interest.
Annexure A/2.
What have you done?
This is my lord, in the low rate of interest they have paid. So for the 18% delayed payment of the retail benefit, it has not been considered, my lord. It has been rejected after due consideration.
Open that letter. A2.
A/2 at page 7. As the papers has not been submitted, para 6.
Because he himself submitted the papers belatedly.
Para 6 and 7.
Right out. Complaint alleges non-compliance of order dated 17/2025 entered in complainant's WPC number 29206 of 2025, wherein a direction was issued for considering complainant's representation for payment of interest on the delayed settlement of pensionary provision. In the light of Apex Court decision in State of Kerala versus V.M. Padmanabhan Nair, so and so, 1986 Supreme Court or something like that. Next paragraph. After service of notice, compliance report has been filed, annexing a copy of the order dated 22/1/2026, whereby the representation has been duly considered and rejected on the ground that the retiree had submitted the papers belatedly only on 4/11/2020, and therefore no culpable delay attributable to officials can be leveled. First of all. Next paragraph. In the above circumstances, there is substantial compliance of the writ, and therefore contempt proceedings are liable to be dropped. First off, accordingly, they are. First, if there is any grievance, the complainant can work out the same elsewhere in accordance with law. In that connection, all contemptions are kept open. Next.
Item 66, contempt 737 of
66, we have also complied the same, my lord, and filed the compliance report on 10/3/2026.
What is
wherein
was the order?
The representation, my lord, this has been considered and rejected.
Representation was for what? In the light of Manoj Kumar Jena.
My lord. This is the comment by Manoj Kumar Jena, that is the appointment of Ganesh Kapil.
There it is rejected now.
Rejected.
You challenge it.
My lord. Liberty.
Yes. In complainant's WP number 7944 of 2018, the order was made on 13/9/2022 directing consideration of representation of the complainant in the light of Manoj Kumar Jena. Petition is different. WPC 32901 of 2025. Order dated 8/12/2025. Okay. In the light of Manoj Kumar Jena versus State of Orissa, WPC number 7944 of 2018, decided on 13/9/2022. First. Next paragraph. After service of notice, the compliance report has been filed, annexing copy of the order dated 8/12/2025, whereby the subject representation having been considered, is rejected. First, there is compliance of substantial compliance of the direction. First, next, in view of the above, the complaint is dropped, liberty to the complainant to work out the remedy elsewhere in accordance with law. Okay. In that connection, all contentions are kept open. Next.
Item 67, contempt 738 of 2026.
Non-compliance of the here, my lord, the compliance report has been filed. I am serving the copy right now. I am.
Kindly taken up next terminal, I go through the matter.
That you have no say at all. This is only one facility which we are giving to you. This matter is between the court and the contemptor.
Because here, my lord, sir, the preferred the SLP.
What was the direction?
Lord, it was disposed of on 18/9/2025, my lord.
18/9/25. What was the direction?
The direction was to Department of Education and Youth Service, that is circular reads as college in advanced area and will receive 1/3 of the deficit granting in aid, and 5 years from the date of government concurrence recognition, 2/3.
They were directed to implement the order of the tribunal. Correct.
Yes.
Whether order is implemented.
A similar matter has been, my lord, they have traveled to Hon'Ble Appeals Court. That
Now, what happened there?
My lord, that is pending, my lord.
No, whether stay is granted.
No, my lord, it has not been issued.
Then that's what.
May take some breathing time.
But you are saying that complaints are no complaints.
Because identical issued.
No. We have highest regard for the court, but we will not obey the orders of the court. That kind of affidavit it is. He always holds the court in the highest esteem. What we should do with that? No, state is awaiting SLP means SLP it is, not even converted into CP, civil appeal. When SLP was filed?
In similar cases, not in the particular cases, my lord. SLP has been filed in similar cases, but not in the case, my lord.
It is not even numbered. It is only diary number.
Diary number of 20.
Perhaps after the order is made, you have gone to the court. No, it's your right to go, but you comply with this order and tell the apex court. We have complied with the order and now set aside the order of the single judge and
some time be granted, my lord. I will take details.
No, I will take strict action against officers. They are only used metaphors, adjectives, adverbs, and metaphors. That is not going to is not the compliance of the order. You take this back. I am not taking this. If you take it, I will take it, but I will reject this. What will you do? I will direct presence of the officers, if necessary, by arrest and detention.
Let it go 1 week after.
Then you will take this back?
I give it, return it back.
Unless our order is stayed, pendency of the matter, we cannot, how many years it will take, we do not know. By that time, the litigant will be dead. Call on 10/4/2026 at the request of learned AGA, who wants to have conference with his clients and come back with the possible compliance report. Okay.
Item 68, content 79 of 2026.
Non-compliance of order dated 8/12/2025, madam. That is the release of pension, madam. That is the coupled by Hemant Chotra. That is
This matter is posted to next month, my lord. That is 197 of 2024. I will take the decision even though there's a file.
Call on 5/5 or something.
Maybe in the month of May, my lord.
8/5. 8/5. At the request of learned AGA. Yes.
Item 69, contempt 761 of 2026.
It's order dated 8/11/25.
69.
69.
2026.
Compliance report is filed. What they have done? The identical paragraphs in all those matters, we hold the highest, same sentences, even comma.
That became format so far this other word. So far the compliance other party is concerned. That has been clarified. My lord, here, my lord, 25/2/2026, the office order. At annexer A kind of.
Okay.
25/2/2026.
Order is the compliance order.
Yes, ma'am. This is the office order.
What is that order? What was the direction? What we have done?
This is repentance.
My claim was for release of substitution alarm. Accordingly, your lordship directed me to file a grievance before the director of higher education. I filed it, but as on today, I have not received the substitution alarm.
You are under suspension. From since how long you have been under suspension?
The period I have mentioned, that is the period 11/8/2023 to 12/2/2025. 11/8.
That I have quoted in para 7.
12 to
11/8/2023 to
12th February 2025.
For this period, I have not been allowed the substance.
No subsistence allowance is given. Oh, the direction was what?
For filing a grievance before the director of higher education, and it will be considered by the director.
That consideration has not taken place. But they have given the office order, no.
It is order dated 25/2.
Order is confined strictly to the compliance with the stated as president being in the governing body will calculate and release the admissible subsistence allowance to the petitioner being the principal employed for the eligible period of suspension from 11/8/23 to 12/2/2025. Appropriate allowance shall be released from their own source of the college within a period of 15 days. The compliance report shall be, he also seeks compliance report. We gave direction and he gives direction to some other person. We ask in compliance and he asks compliance with the other person.
No, the petitioner is an approved employee. So the director is the competent authority to give the salary.
Governing body.
Kindly come to paragraph 4 of your letter. What action you have taken? You have given, see, this order was made on 25/2/2026. You have given 15 days time to the managing committee and you have said if they do not pay, we only will pay.
Yes.
Have you made the payment? You do not pay the subsistence allowance. How to hold the body and soul together?
And next Friday. One.
No, this is very bad. Call this matter on 20th.
Well, 20th.
20. At the request of learned AGA, finally. Yes. On that day, if that money is not paid,
Essay needs to be paid, my lord. After Ajay Chaudhary case,
1.5 years, why has he been kept under
there
suspension?
is no chance to hold this.
If you want,
no chance. Because it is for sustenance purpose. Not for all.
subsistence means he has to hold body and
sustenance.
soul together. So your officers want all these employees to commit suicide. We will direct the police to register a case because it amounts to abetting suicide. If a person is not given subsistence allowance, 20th. Okay.
Item 70, Contempt 795 of 2026.
My lord, order dated 19/11/2025 has not been complied with.
Complied with? Not complied.
Not complied.
What was the order?
The last occasion notices were issued.
What is the order?
Order was to observe the petitioner.
Order is, my lord, to observe, my lord. This is operating part as page 10, my lord. Observe the petitioner therein in any new scheme or project within 8 weeks, my lord.
Yes, what you have done?
This is the first time we are taking action, some time we give.
First time it has come.
No, notices have been issued.
Notice, my lord, we have not yet received any information.
AGA, Mr. Mohanty, seeks a short accommodation to file his reply. Call on 10/4. Finally.
Item 71, Contempt 1012 of 2026.
Yes, sir.
Non-compliant.
Consideration of representation within 6 weeks.
6 weeks.
Have you considered? After all, this is post notice.
Sir, if we just.
Post notice.
Yes, my lord, compliance.
Requisites you are not filed. File requisite.
Can you give me one?
Not report, my lord.
Not
We
report.
have taken the steps, my lord, and compliance report has been filed. So far, the order has been passed in this particular representation, my lord, 11/3/2026.
Saying,
My lord, the operating part, my lord,
11/3/26.
it has been rejected, my lord.
Rejected.
Yes, my lord. 11/3, my lord. This is the
Day before yesterday.
Yes.
Therefore, it has not reached. The complaint alleges violation of the order dated 9/12/2025 entered in complainant's WPC number 34366 of 2025. After service of notice, the contemners having entered appearance to the learned AGA have placed on record the compliance affidavit along with the copy of the order dated 11/3/2026 at Annexure A, whereby complainant's representation having been considered has been rejected. First off, thus there is due compliance of the order. First off, in view of the above, complaint is dropped with liberty to the complainant to work out his grievance against the said order in accordance with law elsewhere. In that connection, all contentions are kept open. Next.
Item 72, Contempt 1051 of 2026.
Yes, sir.
Order dated 10/9/2025. It is university, the government has not. 72. Utkal University is the contempt.
What was the order in the above circumstances?
In the meantime, I have instruction that things have complied, but I have not got papers. So your lordship may allow me a short adjournment for filing the compliance affidavit.
Whether it is complied already?
My lords, last evening I have been told over telephone.
We will call this matter on 20th.
My lords.
Call on 20th at the request of finally. Yes.
Item 73, Contempt 1093 of 2026.
Compliance of order dated 23/9/2025. This is a matter of pension, my lord.
compliance affidavit.
Representation to be considered.
Considered, my lord.
To see that they have considered. What you have done with the consideration? Effective consideration
This is
not
the office
happening.
order dated 10/3/2026.
10/3/26. What have you done?
This is grant of RSCP and MSCP.
Have you given that or rejected?
No, my lord, it's rejected.
Rejected. Almost all everything. Therefore, hereafter will not make any order for consideration of the representation. No use. Okay. Right now. Complainant's WPC number of 2025 was disposed of by final order dated 23/9/2025, directing consideration of the representation towards the grievance. First off, after service of notice, that is the contemners having entered appearance through learned AGA has AGA submit that the representation has been considered and rejected. The void order dated
10/3/2026.
First off, in view of the above, there is compliance of the writ.
It is the case of pension.
First off, in the above circumstances, the contempt proceedings are dropped with liberty to the complainant to work out his remedy against the order dated 10/3/2026 elsewhere in accordance with law. All contention in that connection are kept open. Yes, next.
Lordship, page 13, my lord.
How can once the rejected? What can we?
This is a case of pension, my lord. RSCP, MSCP, they have all rejected. That is not my case, my lord. But I am retired from service on 31st January 2025, my lord.
But they have rejected.
Rejected
only consideration.
Well, RSCP rejected. I have not claimed for RSCP, my lord. My claim is for pension, my lord.
What you will consider the representation?
Well, Annexure C, my lord, they are additional affidavit, my lord. There are compliance affidavit. They have stated that they have already directed to sanction the
300
on neutral leave salary and
300 days
preparation of pension, my lord.
That office order was dated 25.
My case is not for grant of RSC, my lord. My case is grant of pension, my lord.
What have you done about the pension?
Pension, my lord, they are not taken in action. My lord.
Page 13, my lord.
1-3. Go to the compliance of. Give that.
Page 13. The sanction was hereby accorded toward the payment of the cash equivalent to the leave salary in lieu of unutilized earned leave for a period of 300 days left at the credit of Srimati Sri Devraj Mohanty, ex-junior clerk in the date on 31/1/2025 for the period of his service rendered under the government only.
No, they have said that you are not entitled to the benefit, no?
But not entitled benefit, MSc, my lord. I am not claiming for MSc, my lord. I have rendered more than 30 years service, my lord. I am claiming for pension, my lord, and the commanding officer, my lord, where I am working, my lord, he has already submitted the report, my lord.
Where is the order on pensionary claim for pensionary benefits?
13, my lord. Page 13.
Page 13.
This is in respect of unutilized earned leave.
No, what about pension, where is the no whisper about the pension. Therefore, he is saying.
My lord. And this is the order, my lord, already commanding officer, my lord, he has already submitted all documents and also service book, everything, my lord.
Yes, they have sought for direction. May Mr. Mohanty, no.
Para 3. Final pension, pensionary benefit including gratuity, unutilized leave salary, pay fixation, RSP. So far the unutilized 300 days and the RSP, this has been controlled. So far the pension, it has not been used.
Yes.
May be permitted to file a fresh.
You take this. You take
have
this.
to file a fresh.
Yes.
So far the pension part is concerned.
And he has given, see, they have sent a letter, Lieutenant Colonel Officer Commanding has sent a letter to Director Higher Education saying that can we sanction the pension, etc. Sir, a copy of
let them serve a copy. By that it will be easier for me to make a communication to positive
on this matter on 10th of April. Finally, at the request of the DGA. Yes, ma'am.
Item 74, contempt 111.
To 10th.
Contempt 111 of 2026. Item 74.
Order dated 16/9/25. Direction was given to appointment of the petitioner in any of the block grant scheme.
List of mandamus to appoint the petitioners in terms of block grant schemes within an outer limit of 10 weeks in any of the schools enlisted by the district or any other school of the same category and approve the appointment within a period of 3 months next following.
We have filed the affidavit stating that in the state has preferred writ appeal. In 392 of 2020, I have avoided para 2.
DGA submits that state has preferred appeal against the order dated
WA number 392 of 2026.
WA number 392
of 2026.
2026 against the order dated 16/9/2025 passed in WPC number 1898 of 2025. First off, in view of the above, call this matter on 8/5 of 2026 to know the fate of the appeal.
Item 75, contempt 1129 of 2026.
What is the order? 6. Yes, my lord. My lord, there is successive violation of this honorable court's order dated 5/1/26, and after that, while Lordship, in very lucid words, Millard, Lordship directed that in the above circumstances, I'm reading it out, in the above circumstances, application having been
Termination
favored.
stayed, coupled with direction to continue the petitioner in service
Yes,
till after completion of contractual period or till the next date of hearing, whichever is earlier.
that was violated. Again, after that, on 22/20/2026, Lordship issued another emergent police notice to the contemners, returnable within 10 days, in which Lordship clearly directed the jurisdictional superintendent of police shall scrupulously serve or cause to be served the court process and file compliance report through official email to the Registrar General of this court well in advance, failing which action follows.
They have not done anything.
But despite that, nothing means he was not allowed into even the compound of the university, and he was also he has not been also disbursed with his arrear salaries, etc.
Yes. First time notice, first time.
First time notice has already gone. Means
Notice is not yet served. Service related. This court wide order dated. No, wide order dated 20 February 2026 has said as under. Till date, the service report has not been filed by the jurisdictional police, despite a warning administered in third paragraph of the said order. First, there is a serious lapse on the part of the police. First off, next paragraph. In the above circumstances, the superintendent, which superintendent of police?
Koraput is the Vice Chancellor, Koraput.
No, superintendent of police. Yeah, we should have served the copy.
Koraput University, Central University, Koraput. Vice Chancellor.
You better Koraput Central, then it will be Koraput.
The superintendent of police, Koraput, is directed to be personally present before the court on 10/4/2020.
This is in respect of the Vice Chancellor of that university.
Correct. Service has not been done.
Possibly this might not have come because state is not there. Possibly this might not have been communicated.
But there was in clear terms.
This should have been communicated. Whether it has been communicated or not, that
who should communicate?
Police should communicate.
Lordship directed to police.
Police,
to scrupulously communicate.
Personally present before the court on 10/4/2026 to offer explanation as to why the service of court process has not been done on the contemners. First off, the absence on the said date of the concerned superintendent of police shall be viewed very seriously, and adverse orders may be passed. First off, next paragraph. However, in the meanwhile, if service is effected and compliance report is filed with the registry of this court, his presence shall not be required. His personal presence shall not be required.
For better appreciation, may I be served with a copy, order copy?
We'll give that copy.
By that it will be easier me to communicate. Possibly it might not have been communicated to the authority concerned.
Registry to share a copy of this. Registry shall send a copy of this order by speed post to the speed post and email to the superintendent of police Koraput.
Exactly.
First off, it shall also share a copy of this order with the learned AGA, Mr. Mohanty. Carbon copy of the order with learned AGA, Mr. Mohanty, for information and needful action.
Item 76, WPC 37572/2023.
Yeah.
Milord 76, may I pray for any other day? It is in respect of the caste certificate which has been submitted by the petitioner concerned That was
When
not in the
on
schedule
10th
of
April.
1950 million. That presidential order million. So they are saying for that reasons SLC, Madhuri Patil and all this taken care of the things. But so far this particular caste is concerned, this has not been reflected in the
Presidential order.
That is the crux of the point.
This is not my case. Because
Anyway, he wants a short accommodation. We'll have it on 10th of April. That day you have to argue again
Yes.
and again, don't ask
Yes.
time. Huh?
Cannot my earlier restriction was allowed. It was demanded. But again, they repeated the impugned order in this present.
As it is.
As it is. It is my case.
The Madhuri Patil, Laviti Giri, all these judgments, lot of law has been developed now on social status. It began with Basavalingappa, B. Basavalingappa was the state of Karnataka. Two Laviti Giri, two Madhuri Patil was the state of Maharashtra. Then two Laviti Giri was the state of Andhra Pradesh. So look into that and come back. All right.